Good afternoon, everyone, and thank you so very much for joining us today with a wonderful DICOPO webinar. And we have with us also here today some of the original DICOPO members and also organizers of these series of events, Giovanni De Gregorio and Giuseppe Muto. And before we start, I can emphasize the fact that DICOPO is a wonderful collaboration and a collaborative project between different researchers interested also in public policy. And we have a series of webinars on various topics. We're going to leave the links in the chat, and you're very welcome to join also all the other webinars in the future as well. And I believe that the recordings of the webinars are available on the website, so you can also check out the past webinars. For today, we have a very hot topic, something that we noticed that a lot of researchers, but also civil society and also a lot of media outlets have been very interested in: the idea of data access. We have the Digital Services Act that allows for access to something that we can see in two ways. On the one hand, we can see this as just enhanced transparency that we have been expecting from platforms for a very long time, access to data, which otherwise has been very frustrating to obtain, whether from the very limited research APIs or from the very legally challenging scraping opportunities and modalities. And so that's why Article 40 of the Digital Services Act tends to have or to raise very high expectations in many different communities that have an interest in the DSA. On the other hand, we can also consider data access as a very, very great power, because if you think about it, it gives access to information and data about the biggest vulnerabilities of European citizens, and what to do with that, and who should have access to that, how we should manage this access, are just a few of the themes that we hope to explore here today. With me is Jacob van der Kerkhof, who is doing his PhD on the Digital Services Act. He is a PhD researcher at Utrecht University. I'm Catalina Guanta. I'm an associate professor also at Utrecht University. And Jacob is going to chair our meeting today, and I'm going to share some information in the chat as we go along and also contribute to the questions. Jacob, take it away.
Yeah, thanks a lot for the kind introduction, Catalina. I'm very much looking forward to the discussion today. I think we have a great panel with a great variety of views on the issue of data access under the DSA and its sparkling new delegated act on researcher data access. Please join me in welcoming to Joschka Salinger from the Gesellschaft für Freiheitsrechte, Julia Gentile from Essex University, who's lecturing on digital law and human rights, Philip Paspalj from RTR Austria, part of the Digital Service Coordinator in Austria, and Anda Yamnici from Maastricht University, who's a professor in computer science, who might give us more of a practical insight into how we will use data access. Yeah, and I think for each of the participants, we've developed some talking points from which they can shine their expertise on the points that we've identified. And I'd like to start asking Anda, having read the Delegated Act and having seen sort of the hurdles or mechanisms that need to be in place for a researcher to ask for data access, being that you need to ask for very specific data that you might be able to find in a data inventory that's provided by the platforms. But that data is then also provided to you through an access modality that is determined by the DSC and the platform on a proposition of the researcher, but not finally by the researcher. I'm very interested to hear your thoughts on how workable that is for a computer scientist like yourself, and to share your insights on that.
Thank you, Jacob. Hello, everybody. I am a computer scientist by training, but in the last 10, 15 years, I think I work with data from the web, let's say, social media data in the last 10 years, but before that, even gaming data from the Steam community and so on. So typically, our access to data was done through an API. At some point, Twitter was generous, right? So they were the standard of the good guys. The Steam community, which is a gaming platform, also had an API as far back as, I don't know, maybe 15, 13 years ago. And but in my experience, what I want to bring to the table is the fact that knowing what data you want is a very repetitive process. You start doing the research, you have an idea of what you want, you look into the data, and then you realize that in fact you wanted to see something else because it correlates with what you're seeing. So one first question I would have about such a process is, how can you know all you want without asking for everything that is available, right? Before you get the data to just look at it to understand what is useful and then pick the pieces. And if we look at other platforms, let's say in computer science or in computing, that would be time on supercomputers. When people don't know how long they need to run their jobs on a supercomputer, they tend to ask for a lot of resources. So if this translates into requests for data, then it's likely that more data will be requested than is needed or useful, just because people don't have access to this, let's say, thoughtful process of understanding what data they need. So I see this as I don't know how this will be implemented, if there are all the ideas in place, or we need somehow to figure out before exactly what we want and what we're asking for from a researcher point of view. And please step in, I think, with points to discuss at any of these thoughts. Another problem I can see is access for multiple platform data, when what it matters for you is to see, for example, how information spreads between, I don't know, whatever platforms you have, because it's only in aggregate that something really bad, risky, is visible. And then the requests, how are these handled by the DSCs? One by one, in which case, if I only get one request approved, my project is in the air. All requests will be approved at the same time, guaranteed. So this is another unknown in my mind. And then if we're looking at the recent Romanian elections that were canceled in November 2024 or December maybe, after the scandal broke, lots of data was removed. So if you asked for what is visible, you are limited. You need to ask for what is invisible, right? So what is invisible is logs of data that were removed between some date and some other date, and whatever other things that the platforms have, because they have logs of what's happening, even if they don't maybe maintain the data itself. But also other data that the platforms infer. So I think the worst thing we can do is a DSA. Maybe it's not the worst, but one bad thing we can do is a DSA is to imagine that the API that Twitter used to provide is the standard, is the best we can achieve. I think that is extremely limiting. And it's not real transparency. The fact that now things are much, much worse on all the platforms, this is a different story. But I think we should aim for more than the Twitter API used to provide. There were various problems with the data sets coming from Twitter API, but it was the best we had at that point. So for example, the platforms do all sorts of inferences about demographics, right? There are ways in which, because they do provide ads, and you can buy ads that would target, I don't know, the Ukrainian-speaking community in a particular country, for example. This is not necessarily a declared attribute of the users, but it is often inferred by the platforms. And the platforms infer all sorts of other things, sexual preferences and gender and all things that might not be declared in the user account. How much of these informations would we, as researchers, have access to or be able to request, especially when they are not declared as attributes that are visible on the platform? So these are, let's say, the hurdles from the data science point of view. How do you make such a request that would be useful? And the last point I want to bring, the fourth one, is reproducibility. in science and computer science is absolutely terrible with reproducibility, and data science as well, especially in the computational social science space. We can't share data with other researchers unless it's super stripped to the point that it's not useful anymore. How can we validate a big, let's say, result that may lead to accusations that are quite serious, right? You'd rather have multiple teams that independently work on the same problem. They might request different types of data, but they would be focused on the same big problem. Do we have provisions for this? Is it something to look for? Is it something to even at some point proactively engage different groups to look for this in order to bring more evidence in a very serious case, for example? So these are the my unknown. I don't know if you guys solve them on the legal part, on the procedural part, or the enforcement part. And then, so this is how do we formulate, let's say, scientifically our needs for data. And another aspect that Jakob, I think, mentioned was data modalities. In what format do platforms give access to data? And I'm not the right person to talk about this because we computer scientists have all the fancy tools and knowledge to deal with bizarre formats and so on. I think the challenge is more for, let's say, political scientists or people who are working with data but not necessarily don't have the programming tools, the expertise, or the time and the resources to go deeply into, I don't know, data structures and other things. So I don't have much to say in that space, but what we would prefer is to be able to download the data on our, of course, safe storage environment, protected from outside attacks and so on, and be able to use and develop our own tools to access the data and process the data, as opposed to be in a sandbox provided by the platform where we would have a very limited computational access for processing the data.
Yeah, thanks a lot. That was super insightful, I think. I saw some signs of recognition from Philip because I feel like I'm really wondering how you look at this from a more of an operational perspective, and what are your views on guaranteeing data access from multiple platforms, for example, if that's something, or the reproducibility of data and sort of the asking for invisible data as opposed to visible data, because we also know that in that same delegated act, it says, well, you cannot ask for sort of more data than you need. There is this sort of subsidiarity requirement in there. So I'm really curious how you look on that.
Oh, well, my answer is not going to be very satisfactory to you. Also, maybe as a disclaimer, I can't really give any legally binding opinions here, of course. And also, I'm from the very small DSC from Austria, which is, in regards to VLOPs, of course, a non-establishment DSC. I was just nodding because this is, of course, something that we, or at least I have heard in the past. I think like these are the questions that researchers bring to our attention a lot. So this was sort of just to reassure sort of your heard. I feel like these are things that are being discussed. Maybe I can give you like an insight on what our structures are at the moment, because I feel it is sort of twofold when it comes to the DSCs. On the one hand, you have you're part of the, like, legally speaking, you're part of the vetting process for researchers when it comes to non-public data, of course, where also the roles of the non-VLOP DSCs is also limited, but still they do play a role here, especially when it comes to the initial assessment. And what we as DSCs have agreed upon is that we will have, and this is also something that has been published by now, that we will have a memorandum of understanding where we beneath ourselves clarify elements that are not in the delegated act, because of course the the area of the delegated act is limited. The scope is very limited because of the DSA. And then we will have a memorandum of understanding where we will also talk about the scope of the initial assessment, etc. So maybe so if it's still ongoing discussion, that is one part. And we also, of course, we have this working group of the Board of Digital Services that is dedicated to data access. And then the board, of course, is discussing data access issues as well. And then the second part I wanted to mention, which I think is also
Philip, I think we lost your audio.
Yeah, we lost your audio for a minute there, I think. Yeah, you're still, we cannot hear you.
That's some unfortunate platform censorship at the right moment.
Yeah, still not. I'm very sorry.
Is it now?
Oh, yeah.
Yeah, okay.
Now we can
I
hear
have to
you.
switch. I don't know, my headset is, yeah. Anyway, what I was trying to say is that really the coordinating part is, I think, crucial as well. Also, when it comes to data access, the DSCs there's this provision in the DSA that the DSCs shall transmit information they have that might be important for ongoing proceedings. So far, the European Commission has started or has opened proceedings in regards to Article 40, if I'm not mistaken, towards the meta services in X. So I feel like this is also something to keep in mind if you experience, as researchers, if you experience possible infringements, to really reach out to the national DSC to provide this information, and I mean eventually to provide evidence. And then this is also sort of, I think, the part of the DSCs that are not VLOP DSCs to collect this information and then transmit it to the Commission in regards to the proceedings.
Yeah, thanks a lot for that insight. I think there's a very sort of nice bridge there as well to Joschka's work. Also on the earlier part where Anna was describing Twitter's API as maybe not the most ideal source of data, and asking for visible data as opposed to non-visible data. You guys chose a different route as opposed to going to the DSC. You took X to court. Would you care to explain a little bit more on that, how that all went down?
Yeah, sure. Maybe to make things clear, we also we provided this evidence to the DSC as well as to the European Commission, which we are very happy to do. But as we are seeing, those proceedings pan out rather slowly. And we, as well as probably most of you, are a bit disappointed by the fact that the DSA has now been fully into force since more than 2 years. And procedures for Article 44 are not still in place yet. That's why Article 4012, access to public data, has gained much more attention and traction in the past months. And probably many of you already have practical experience with data applications under Article 4012. We as GFF, we do not. So we are a litigation organization. Our intention has always been to help researchers make use of the provision in a meaningful way, that is to provide legal advice and, if need be, assist in litigation. And what we hear from researchers and civil society organizations across Europe and in Germany is that Article 4012 currently does not work very well because the platforms handle it very arbitrarily. So, and one way to help overcome these fundamental flaws that Article 4012 basically requires researchers to gain access vis-a-vis the platforms themselves is either to go through the Commission and the DSCs, or to try litigation. And yeah, I think winter 2024, we were approached by DRI, Democracy Reporting International, a German-based NGO that is doing research on elections globally, with a focus also on social media discourse analysis. And DRI had applied for access under Article 4012 against X I think in June 2024, and X had not given them access yet, neither had they provided a final decision on the application. So at one point then we said, okay, that's German elections were approaching surprisingly quickly. We saw the need to file an interim, to apply for an interim injunction in order to get access a meaningful time span before the elections would take place. And actually, we were not very confident that the court would order this decision, grant us this order, because our biggest question in the case was if the court would, if we would get jurisdiction in Germany with a case that pertains to a platform which is established in Ireland. So in the end, we did a very thorough writ and put out all the arguments why we said that we would say that we have jurisdiction in Germany based on the Brussels 1A regulation, and that Article 4012 can be seen as a tort claim because it pertains to damages. And in the end, the court followed our line of argumentation and issued that court order. And there was really hardly any problem with the substantive requirements of Article 4012, which is really clear because what DRI does is research on systemic risks. So it was really a clear-cut case in that respect. But we were to some extent surprised that actually the court followed our line of argumentation on jurisdiction. However, X in the end did not comply. So we tried to, or we actually began enforcing the court order in Ireland. And then around, I think, 12 days later or so, X then filed a written objection. And we still do not have a date for the oral hearing on that yet. And the way X handled this also sheds some light on the willingness on the length that researchers have to go against a platform like X, because now they are spilling paper on us. They are kind of bullying even the court. So this is really lots of work, but we are confident, and this is from our point of view, maybe the biggest success is that our line of argumentation on jurisdiction will uphold. So we hope that the court confirms this after the oral hearing, no matter on the other details, but this would allow researchers to file litigation in their country of residence against platforms to enforce access under Article 4012. Yeah, and maybe what we actually asked from X was, or asked the court to force X to do, was to provide access to access researcher API. So just access to all public data, and we still think that this will be, or we hope that this will be feasible in the future.
Yeah, super interesting reflections there. Do you think that the jurisdiction argument for Article 4012 is something that you could at some point also follow in Article 44, so the vetted researcher data access, where you'll be able to sort of seek for remedies in that respect in your own nation state, as opposed to sort of the Irelands and the Netherlands of this world where all the VLOPs are located?
Well, that's a very good question, actually. And I haven't thought this through completely, but I'm not very optimistic because both provisions are completely different, as you know. So Article 4012 is civil law vis-a-vis VLOPs, and Article 44 will be mostly administrative law against the regulation authority that in the end does not issue a favorable decision. And this will always be in the end Ireland, and I'm not sure on how this really works in international administrative law. I mean, Brussels 1A regulation is civil law, right? I mean, so that's commercial law, and Article 44 go against the regulator in Ireland is completely different. So we have not thought that this would be a possibility. I mean, in Germany, we're kind of blessed that we have Zalando, which gives us possibilities to go after them in Germany, but for the rest, I'm not very optimistic.
I mean, thanks so much for that. I was wondering, we've also spoken a little bit about vetting researchers already, and I think I'd be very interested in hearing both from Julia and from Philip on this, the vetting of researchers and then providing data access to researchers throughout Europe, but perhaps also outside of Europe. So yeah, perhaps Julia, you'd be able to share your views on how that would sort of operationalize in practice, and then I'd be very interested in hearing from Philip what his views are on sort of on that what you've said.
Yes, perfect. Well, first of all, thanks very much for having me. This is a very interesting discussion, and there are so many complexities as well as I would say goals that Article 40, the Delegated Act, is trying to combine together. And this is why I think we're really dealing with something that a problem in front of us of really not easy solution. And I think that to add to the mix of known, unknown, we have also, of course, the problem of data access for non-European researchers. And this brings, of course, to the scene many issues. First of all, of course, we are in the realm of international data transfer, international personal data transfer potentially, and this raises questions from the perspective of the GDPR, if of course any personal data is involved, and therefore a big issue I think that should be dealt with is really how the system will work, in particular when, for instance, researchers are in a jurisdiction when, for instance, there isn't an adequacy decision. So it will be very interesting to see whether the other mechanisms for international data transfer could be used somehow, and therefore how the safeguards that are provided under the GDPR would be triggered in this context, if we, of course, recall all the lengthy and complicated Schrems saga around all the complexity of the case. I should say in this context that, of course, the scope of the research, nonetheless, the researcher's data access is quite narrow. So it will be very interesting once again to see how the broad, the narrow scope of data access requests concerning the systemic risk research with the GDPR will interplay. I think another point that is worth raising in this context is that, as we know, historically, from the GDPR, there are some, from the GDPR perspective, there are some jurisdictions that are key in this context that therefore, because of the presence of key actors, might therefore constitute hotspots for data access requests under Article 40 of the DSA, and therefore thinking about many VLOPSs being located on many on a few member states, there is a risk really that the DSCs of these jurisdictions will be overrun with data access requests. And therefore, ultimately, the system will be congested. So there is no system of priority for data access requests. So it will be very interesting to see how this potential overflow of requests could be dealt with in this context. And to this, I also would like to add, I would say, geopolitical concerns. Of course, this is a slightly side point, but one that perhaps is worth mentioning, considering, of course, the very delicate geopolitical context in which we are living, and looking at the competition between jurisdictions. I think it will be very interesting to see whether there will be a, so to say, there will be concerns around security for requests coming from jurisdictions that might, so to say, pose a threat for the security of the European Union.
Yeah, thanks so much. That's exactly what I was looking for, and I'm very much looking forward to Philip to reflect a little bit on that. Maybe not on the system congestion as being, I suppose, part of a smaller DSC that doesn't actually deal with VLOPs that much, but about sort of the vetting and of non-EU researchers and sort of the data protection concerns, but then also maybe the geopolitical concerns that accompany that.
Well, in this regard, I also have the privilege of a small DSC which will only accept applications by researchers that are based in Austria. That is for sure. But maybe still on the process, and then I'll try to say something on this as well. So of course, also maybe on the legal issues we just discussed with like different jurisdiction, etc. We are trying to be very cooperative in this manner, especially with the Irish DSC, of course, and all the others. What we try to avoid, I think I can say, is that we have a sort of this bottleneck where all applications go straight to the Irish DSC. That's why I mentioned this MOU before. We try, I would say there's a commitment for the national DSCs to sort of cover within the legal framework, which is the initial assessment, of course, the applications from their research organizations. And even in this regard, to just because we have talked about administrative legal issues, our accompanying law, for example, in Austria, asks us to give a formal decision within the initial assessment, which would also sort of, at least from like a time matter, it would take much longer than just to have like an informal decision in a way. And then again, talking about the deadlines maybe, because this is also something that was covered in the Delegated Act, and I think this probably also of interest for researchers, that we are also trying to streamline sort of the applications and the processes in order for them to not take too long. However, we have expressed this in our feedback to the consultation of the Delegated Act, that the deadlines that are foreseen in the draft right now might be a little how to say, a little close. And then finally to the proceedings, is that at least the benefit of it having taken so long is that we at least have experiences in certification processes within the frame of the DSA. A lot of DSCs have already certified trusted flaggers. They have experience maybe in certifying out-of-court dispute settlement bodies, which in a sense are similar proceedings to the one of the vetting researchers. So this might be beneficial now that it taken longer. And then finally, what is also part of our assessment is, or could be, let's say, the consultation of other authorities who have expertise in certain areas. For example, the data protection authorities when it comes to the data security, etc. Therefore, and then maybe to end my statement, also when it comes to applications from non-EU applicants, etc., we have resources sort of, as I just said, we could consult other expert authorities to help in this regard. Hope this made sense.
Well, thanks a lot for sharing that. I think that's really so interesting that you see that sort of the size and the location of your DC will very much determine also how you reflect on that delegated act, and the deadlines I've heard from other smaller DSCs can indeed be an issue. Which also, I mean, calls for hopefully later in this session a reflection from Anna on how sort of the timeliness of the data access is also relevant for dealing with those deadlines, but also dabbling in data access requests. Catalina, you have another line of questions, I think, or talking points that we can discuss.
I think we can have multiple webinars actually on this topic, because you're all bringing up very, very interesting points. And what I very much enjoy is that we have a regulatory perspective, we have a technical perspective, and we also have a legal perspective. And all of these are very relevant in interpreting Article 40. Going back to Anda, I really, what really echoed in my mind when you were mentioning, the expectations and also the history of data access in a more private governance perspective, such as Twitter giving access just from the kindness of their heart before they became these really kind of bully opponents that Yosha was mentioning with their new platform X. I was wondering, what kind of academic standard do you think should be involved in Article 40 data access requests? Because you were mentioning, for instance, reproducibility, the idea that you should have a data set and maybe multiple teams can investigate that. We know that there have been so many very diverging results and diverging findings, I think, in a lot of fields. I think there's still quite a lot of controversy, for instance, when it comes to the studies about elections and meta and how users are influenced by different information that is funneled through algorithmic recommender systems. So do you think that with Article 40, because we're talking really about systemic risks, and I'm going to try to activate Julia in a second, and also Yosha as well, we have systemic risks. We might not necessarily know what they are entirely, but we know that they are something really essential. So does that warrant maybe a very high standard in science, where we're talking about the meta reviews, we're talking about these kind of team efforts where we really want to make sure that we have real findings and not findings that can be influenced by whatever biases that come from maybe the lack of multidisciplinarity in a team, or things that perhaps have been plaguing a little bit the different fields of computational social sciences and computer science in general. So do you think that that would be a high standard, or do you think that perhaps we should have a lower standard, because we don't even know what we don't know in terms of systemic risks, and we should be allowed to experiment as researchers?
So it's a hard question. There is this play of platforms protecting our privacy, and I'm very grateful for it, but all my data is theirs, right? So I'm not sure what they are protecting me from. I do believe that if you give scientists access to data and they are doing science and not trying to, and most of them are doing science. It's Facebook employees who were caught snooping into people's private lives for various reasons, not scientists who are trying to dig into other people's lives. But anyway, I think data is necessary to be accessible to as many people as possible. So I would say that the threshold should not be there in giving people access to data, except if it is a risk. So if we believe that there are some bad players involved in a particular situation, giving them access to data is making everybody more vulnerable. How can you understand who's who? Because it's not only where they come from, right? People are now everywhere. So does a name that sounds as from a region but comes from a different region, should that signal the DSCs? I don't know, and I don't want to suggest an answer for this, but I think it's a very complicated issue. So on one hand, I think data should be much more accessible than it is now. then this sort of levels the play field. It's not only MIT and Stanford doing the research because they have the, let's say, especially Stanford, they have the connections, or they used to have the connections with the platforms that would grant them data. But you can have teams from smaller places who are looking at different problems than the big players would look at, and they would be extremely important for science, for example. On the other hand, if you are to make a case that stands against the Facebook lawyers, that Facebook is doing something that is a systemic risk, then you really need to know what you're talking about. And then maybe one team with the best science practices might still benefit from a checkup from a different team, looking at the same data and the same problem, in fact. So I think it's I don't think there is one size fits all. And I am very aware that my desires as a scientist have very many challenges on your sides of the problem in terms of regulations and enforcement and legal and all sorts of risks that I can't even think of. So I don't know if there is one solution.
Can we maybe think, and you also have quite a lot of insights into the popularity of the data access topic, also in computer science, particularly social media circles and communities. And do you think that perhaps we have too high expectations from Article 40? And do you think that perhaps we can mitigate some of these expectations with other transparency measures? So, for instance, what should be left for auditing? We have also the DSA transparency database. Should we just put all of our eggs in the basket of data access and then just hope for as much access as we can, or should we interpret this a little bit more conservatively?
No, but when you have the webinar about scraping and what's wrong with scraping, please invite me. I want to listen quietly. But yes, there are very high expectations. 2 years ago, I was at a conference when somebody was already teaching people how to write data request proposals. Last year, there was in the States a panic type of workshop in which people say, oh, we have to be together and try to get data because now everybody was against us. This year, again, there is a workshop that will promise to teach us how to access, how to make requests for data. Do we want too much from Article 40? I don't know. Yes, we want a lot from Article 40. Do we have other ways of mitigating this? So that webinar on scraping, please, people, from legal point of view. But what other things? I don't know. I think it's obviously there is a bad guy and a good guy's perspective now. And while before it was less so, it's super antagonizing now. At the same time, we are in danger as society, I feel, not so much because of misinformation, but this disordered discourse type in which the winner is the one who pushes the narrative louder, not the one who has reasoning or truth on their side. So because of this, I think we're in dangerous times in terms of what's happening on social media. So some transparency might feel, helpful.
Maybe if I could just jump in quickly, because Catalina, you mentioned the question if we should interpret Article 40 conservatively. And I would strongly argue against that, because I mean, Article 40 gives us now finally a chance to balance powers again, or to regain a balance of powers. And it is already a provision that takes interests of platforms into account at multiple points levels. So we have the vetting procedure, we have requirements of necessity, proportionality, we have the relation to systemic risks, we have the trade secrecy objection, we have a mediation procedure. So if in the end, then platforms still do not comply, I mean, that really sheds a light on their understanding of academic freedom and kind of the transparency they are willing to give. So I'm really not willing to step back one toe on Article 40 and progressive interpretation.
I totally hear you. I'm trying to play devil's advocate here as well, and try to see how we should interpret Article 40 in the context of the transparency mechanisms that the DSA provides. But going back to what you were mentioning also in your contribution earlier, which was really fascinating, so we have some legal scholars in the room who have been really focusing on the DSA. So all of these questions, we're going to come back to systemic risk as well. And I think sometimes we have this question of, okay, we don't really see a lot of innovative case law that really tackles innovative questions. You are making this case law, so that's kind of a dream come true. But then you're also saying, well, we actually had to go and try to enforce our decision because platforms are not playing ball. And also because you notice that X has becoming, even you were saying that it's bullying the courts. And we saw that also in Brazil. We see that X right now has a CEO that's bullying countries, governments, not to mention what Elon Musk's involvement in the German elections has been recently, in the Romanian elections as well. So we notice also that, for instance, right now Mark Zuckerberg is perpetuating the same type of narrative. So it's not just X that's the like the bad seed, but it's a platform kind of wide paradigm shift. And so from your practical perspective, seeing the law applied in practice, how do we deal with that? If platforms are going to basically say, no, we're just not going to play ball. Do we get into this tug of war where it's going to be a matter of, are we going to get to the suspension of services because platforms don't really want to comply? What are your thoughts? And what do you think would be a good solution in this respect?
Well, that's the really big question. And I'm afraid I don't have a comprehensive answer on that, of course. And also, it may still be a bit early to make like a serious, to give a serious insight on that. However, I still think that the DSA is a very good law. So I'm actually a big fan of the DSA and the way it distributes responsibilities between regulators as well as private enforcement. So I think we're still at the very beginning to see how far this will bring us, and we will see it much more quickly than we had expected, maybe because of the fact that we see the paradigm shift in the platform's behavior right now. But I'm still very confident that at least in Europe and most European countries, basic principles of rule of law still apply, and that it will be the normal case that actually companies will adhere to decisions by the judiciary, and that in the end also the EU Commission is not is not letting themselves be bullied through pressure by US companies, and in the end are willing to follow through on their proceedings that they have opened now. And if this really in the end will lead to the most severe measures that the DSA allows, we will see. And then but we haven't taken the first steps yet. So we're taking the first steps yet, but we're not sure where this is going to lead. And if this does not prove effective in the end, then we will maybe also have to shift our focus to other tools, such as competition law or whatever. But I think the worst scenario would be if regulators, civil society, academia would in the end back down and put our interests behind those of commercial interests of big platforms. But I'm also, very interested to hear what the other participants in the room have to say on this question, because this is really, this is, I would be very, happy to learn more.
That is also the question of the day, because if you look at what the White House was mentioning on the 21st of February, so a little bit under a month ago, it was mentioning that the actual enforcement of European laws, such as the DSA, would be considered by them overseas extortion, and that they would take repercussions, they would actually take measures to retaliate if US companies would be forced to hand over their intellectual property, as you were mentioning before, right? That the idea that you would have trade secrets and then you could still protect that. So there's even a lot of misinformation about the DSA in itself. But are there any other thoughts about what Yosha was mentioning that anybody would like to jump in? because otherwise I have a question for Julia about systemic risks.
Well, I'll jump in and then probably we
Please.
can talk about systemic risks. I had a comment on your previous question on the threshold to apply, and I find myself in agreement with Joshka in the sense that if we look at paragraph 5 of Article 40, the impression that one gathers is that essentially it could be quite easy, of course, to refuse access, and this is in the power of the VLOPs, and in particular, that would be linked, a refuse, to protection of confidential information, including trade secrets. So we see that the test, as it is devised, it's already quite favorable, I would say, towards refusing access in a way, and therefore protecting the interests of the platforms, and therefore, I mean, we need to be very cautious of the imbalances of powers and also the raison d'être for Article 40, right? So I fully agree with Joska on this. And when it comes to systemic risks, I think that again there will be probably hopefully soon a very strong interest in hammering out really what we're talking about when we talk about systemic risk, looking precisely at what Catalina was mentioning, happening from overseas, and the geopolitics of digital regulation and the blackmailing in a way that is been taking place, regulatory blackmailing, as I call it in a recent piece on the geopolitics of digital regulation, and I think that the reality is that so to say, it would be very hard for the European Union. So I'm also in a way quite sorry for the institution, because of course we want enforcement, but the reality is that it's absolutely complex, and finding the right balance on when to enforce, I think it's even more important than the question of what we enforce. So I think that when is probably, and how is probably much more crucial.
Thank you very much for that. And also for just building on what Joshka was mentioning, I think maybe there would be a very important initiative to be had here. And I don't know if the DSA Observatory, so the University of Amsterdam has the DSA Observatory that is following all things DSA. To my recollection, they haven't done that yet, but maybe we should actually just start a super traditional comparative law database with case law from every jurisdiction, because Joshka, there's also some cases, there are some cases against X, or at least there's one DSA case against X in the Netherlands on shadow banning, not on Article 40. And perhaps that would also be something very interesting for DSCs to see, okay, what is the national litigation like? And, on the one hand, we could also have a webinar on scraping, but then also we could have this very traditional approach to seeing what's happening in different jurisdictions. And taking this geopolitical implication to Philip and DSC, the experience of a DSC, perhaps we can speak a little bit about the independence of researchers. So how would you ascertain this independence, and why is that important for this process of vetting?
Thank you. Very interesting so far, and also I really also understand my role here today as also to listen and to get your feedback. Really, you can imagine, as like taking the regulator's head today, I'm not but anyways, independence, also something we have experience with. I feel like this is somewhat okay. I feel like I mean, first of all, the vetting, part of the vetting is for the researchers to not have any commercial interests, if I'm not mistaken, and then for them to be independent from commercial interests, but also from the providers themselves. We have a similar provision in regards to the trusted flaggers that have to be independent from providers of online platforms as well. I think this, and maybe this also brings us back to voluntary cooperations that researchers and research institutions have had in the past with providers of intermediary services, and especially with VLOPs. However, and I think this is also, again, the benefit of having an initial assessment or having an assessment through a local national DSC, because usually they would at least be aware of the research institute, or like the research organization that applies. And I think this way it's easier and maybe not as much effort to assess the independence, especially from commercial interests, but also from any negative influence of other VLOPs, for example. Yeah.
Thank you so much. I'm also looking at the researchers in the room. Do we have any questions from the room? Any comments? Does anybody want to talk about current affairs? We can use this as a safe space to discuss and to address some of the changes in the political paradigms that we have been used to in the past years, and that no longer, unfortunately, are applicable. Do we have any questions? Because otherwise, I think Jakob and I still have quite a few things to ask about. Any questions from the room? So far, not. Perhaps if you...
Maybe I can just add one thing, because I wanted to pick up what you said earlier, although I don't want Article 40 to be understood too narrowly, but I still think it's important what you said, that we have a lot of other transparency measures, obligations in the DSA, and from the transparency database to the risk assessments, et cetera, et cetera. And I feel like also for sort of let's not forget about them, let's say, and make sure we also, I mean, there's certain provisions, of course, for the board and for the DSCs on how to handle these reports, but from our side, we're also very open to have this conversation with researchers on maybe transparency reports from local services. So to not only focus on the VLOPs, because I mean, certain risks also, they might not be systemic risks, but certain challenges also arise from non-VLOPs, so they're there as well. And this also, I definitely, I like that you said that we should at least also keep it in mind that there's other possibilities to sort of supervise and assess what the platforms are doing.
Yeah, because I think I have one question that I would like to address to all of you, and that's also from a procedural and administrative, but also a legal perspective, but also from a very, very technical perspective. How do we scale our expectations for Article 40? Because so Ireland is still going to be a very important jurisdiction for us. How do we avoid a situation where we're going to see maybe, you know, the same thing what we saw with the DSA transparency database, that from one day to another we could see really the invisible became visible, and we could see the absolute scale of content moderation decisions. So now with data access requests, I'm curious, you know, what we're going to see in terms of actually how many. Are we going to speak about, you know, like 20, 30, or are we going to speak about thousands? And if so, then how do we actually scale these efforts so that we have access to data from European researchers, maybe from non-European researchers, who can bring something to the table that European researchers can't. But how do we scale this? Are there any thoughts on this? And Philip, that's a very difficult question. So we don't want to put you on the spot in terms of answering the very, very tough, also very political questions. But yeah, if there's anybody who has some insights into this or would like to share something. Julia?
Well, yes, I'll go ahead. So thinking about the requirement for also the research that is built on data access to be made available, I think that that would be very interesting in the sense that, in a way, the request is linked to producing research, and it would be very interesting to understand how this transparency requirement, because it is a transparency requirement, will be applied. But again, I think that a lot will depend also on what kind of data can be accessed, and thinking about the hotspots and the balancing with trade secrets, whereby essentially the request can be amended to protect trade secrets. It would be very interesting to see whether perhaps compliance from platform maybe just a ticking box exercise, whereby, well, this is only what we can give you. We cannot give you more because otherwise it would be problematic. And this is where other mechanisms, I think, should play in. But I think the scalability will be very interesting, and it will be also very interesting to see whether this article will become popular, because I think that there are many procedural hoops to be jumped. So in a way, it might not be the first choice, perhaps, to trigger this, even though we are listening about litigation happening in this field. But at the same time, I think it's still to be seen. And my prediction is that this could be a very interesting area, above all from my perspective, for balancing purposes, how to reconcile these various interests, how to reconcile the protection of the various actors, and also the public interest in ensuring accurate research and cooperation from platforms. So I think that this is certainly a space to be watched. Thank you.
Great. And Jakob, you also had a question.
Yeah, so thanks a lot for the insights so far. It's been absolutely great. And for anybody in the audience, please, if you have something to ask, this is a super knowledgeable crowd, so please raise your hand. But for me, I was wondering about, we see that we have created this juxtaposition of platforms and researchers, where the platform is relatively hostile, at least that's the vibe that I'm sensing so far, towards the researcher in creating data access. Now, let's say that you have successfully filed a data access request. The DSA grants it. The Irish DSA has enough capacity to grant that data access request, and you end up with data access. Let's say that as a researcher, then somehow you make a mistake, or you give the platform any sort of indication to say, well, okay, look, we're withdrawing data access for you. This is not working. Either you violate the data access modality or whatever. Then you're left as a researcher with all this super sensitive data that is now withdrawn, but that might also cause liability for you as a researcher for the damage that you cause for the platform. I'm wondering if you've thought about sort of whether the data access delegated acts provide sufficient safeguards for researchers in that respect, and not sort of have a data access request backfire, and whether the delegated act sufficiently sort of underscores that vulnerable position of the researcher towards the platform. So I'm very interested in hearing sort of your thoughts on this, because this might not be a super realistic point, but I'd still be sort of interested in hearing about it. If anybody wants to jump in, please do, and otherwise, if there is not a clear answer to this, that is also fine.
What I can also add to this point is actually a lot of the researchers I've been speaking to we're concerned about the position of the David versus the Goliath, right? So, I mean, governments are in an asymmetrical position towards platforms, let alone researchers and individual researchers, where we also have a lot of administrative procedures. We have institutions that are very, very GDPR averse, that are going to try to err on the safe side. And right now, it's also quite interesting to see how to communicate the ambit and also the expectations of data access in such a way that it doesn't lead to institutional policies that are going to be limiting the expectations that we can have about data access. So but I don't know, Anda, for instance, can you remember any such, war stories from computer science where researchers have been pursued by platforms? Was that something that you've seen? How did that go?
Well, with a lot of lawyers, and in the end with apologies from the scientists. So the example I know is with Facebook early days. A group of scientists were trying to see what is the mechanism of infiltrating bots in Facebook. So we're talking about 15 years ago, maybe 13 years ago, 10 years ago. And they discovered that you create these fake accounts and you automate that. There is a script, a program that runs and behaves as a human. And it was back, before the big hype about AI and such. You could still programmatically say that you take a code from some database and you put it time to time in your line, and it appears as it's an active group, and you populate the accounts with pictures from some other website. So it could work very well. And they discovered that if you first, of course, friend the bots among themselves, but the moment one of the bots asks for the friendship of a human and that human accepts, then the next thing to do is the bot should target the friends of the human. And then it's the hard part is to get the first human to accept the bot's request for friendship. And then because my friend is friend with the bot, I will accept the request from the bot, despite the fact that I have no idea who the bot is or if it's a bot, right? So they discovered this, they published a paper, and then Facebook came after them. And then, of course, the lawyers of the universities are annoyed that they have to deal with this, and the power balance is not in anybody's favor, not in a university favor. It was an university in Canada. And the lawyers were not the friendliest people towards the scientists. In the end, they had to stop publishing on that data set. They sort of had to promise that they will be good citizens of Facebook. And but one of the students involved in this got an internship at Facebook, sort of okay, we know you can come and work for us, swear you'll never talk anything in your sleep, but yes. So that is one example, but it's in academia, it's fear of this. I mean, the lawyers of the university will tell you not to do anything stupid because they don't have the tools, the capacity to protect you and to protect the university.
Yeah. So, Joschka, do you also take cases EU-wide or only from Germany? Because perhaps your institution is the future of this conversation.
No, we're working mostly from Germany, but with European partners, also with partners in the Netherlands, Bits of Freedom, for example, we would be taking up cases in other countries as well. And also, and while I see that there may be a risk for researchers in working with sensitive data, I think it's not higher than in any other context. And also, I'm not very sure if this is a likely scenario or how likely this scenario is. I mean, there's some likelihood, of course, but in the end, again, researchers and the institutions will have to provide a data protection and security concept. And this shifts, I think, especially responsibility and also liability more to the institutional side than to the individual researcher. So if they do this thoroughly, and they should, this will in the end be checked by the data protection officer of the institution or whatever institution the data it will be that processes the data. So I wouldn't see. I hope that that does not lead to a kind of chilling effects for researchers to even file a request for data application, because in the end they could end up with sensitive data that they are not able to process securely. So I think it will rather be the opposite case, that they will apply for sensitive data, and in the end they will end up with something that is not sensitive at all, and maybe not even that useful at all.
In this case, it was about Facebook's reputation. This was the risk. So it's not so much about sensitive, or depends on what sensitive data means, right? But it's in this case was Facebook's reputation. Yeah.
Yeah, sure. Okay, so then this may lead into the realm of SLAPs, so-called strategic lawsuits against public participation, where bigger companies make use of their structural superior position in order to abuse the law to silence criticism. In that respect, that's also something that we have an EU directive now about. So maybe those two can kind of work together. Yeah. But maybe one last point to the point that Catalina had just mentioned on scaling. And I cannot say much about scaling, and I have really no insights on this. But what we are trying to facilitate is to strategically file requests. That is, it can be requests with a very narrow scope and very clear relation to systemic risks, and a very clear cut and high threshold security concept, in order just to make it work once. Can also be the opposite. So with a very broad scope, and we're trying to facilitate this. And there's also a group of civil society organizations that is coordinating on this. And I think those are steps that are needed in order to try to make the provision robust, and to see where this leads, and to coordinate things. And also, I think there's some of this, at least, is in the Delegated Act, with the data access portal, and the idea to it that you have to provide at least that the applications, the summaries of the applications will be publicized. And I think that also may streamline the process of seeing what will work and what will not work.
Thank you very much. Anda, do you have a follow-up to that, or another point?
I would like to comment on the comment that Joshka made about how do we help succeed this DSA, right? It's an apparently powerful tool. I'm also a fan from my uninformed side, right? Also because I moved from the States 4 years ago, and the fact that there is a law here that you can access, and hopefully it helps with the Wild West a bit of social media it's a very nice thing. And I like the idea that we don't have the scientists against the DSCs, who are the gatekeepers to the data, and then sort of alone with the platforms, right? So if the idea is that you could have a collaborations between the scientists and the DSCs to make the DSA successful in providing transparency, what can we do? What can the scientists do such that you guys don't deal with an amazing scaling problem? You can do the work you need to do. Where are the points of discussion, let's say, where we can be friends, and we can tell you what the pain points are, we can tell what the challenges are, and we can find a process in which we know what to ask and how to ask, and you know what makes sense and what doesn't make sense.
Was this a direct question, right? Or did I?
Direct, not a rhetorical.
Yeah. No, I mean, I agree that this is what I was also trying to say, is that this coordinating part of the DSCs, and we are, at least but I mean, I'm pretty sure I can say it for my colleagues as well, that we are always open for this conversation, and I think it's very important to have it. And to learn from that. And it's, again, if you think of other roles within this like DSA framework, and I've mentioned it before, the trusted flaggers, for example, of course, we're sort of in touch with them as well. And maybe even before they apply, we would have conversations on what they would need to bring to the application. Would we think that this organization fits the requirements, etc.? And I feel like for sure we should have this with researchers as well. in regards to their research and their research questions. That's why, again, I was sort of trying to highlight the importance of also having these initial assessments on the member state level, because maybe just because the Irish DSC will have a lot of applications to decide upon in the end of the day. And that's why I can't give you a definite answer now, because we're waiting for the delegated act. Of course, we're waiting, and I sort of mentioned this before, the MOU, which I think will be published as well once it's finished. And then we can see how we can sort of maybe institutionalize some sort of discourse between the research community and the DSCs. But of course, very open and welcome to that. And I think a lot of DSCs are already doing this. At least for me, I can say that we are in touch with sort of our local researchers that work in that field. We organize events where we invite them and have conversations. We are funding studies on certain issues. So this is, and then maybe something that we have, Catalina and we have talked about this in the past. Maybe also DSCs could have conversations with high officials within universities, because as you just mentioned, we trying to sort of, I know from what people have told me that sometimes the rectorate or the dean's office, they're very sort of hesitant when it comes to signing certain projects or like applications. So maybe we could also help with this to sort of come up with processes that are clear and legally safe, let's say.
Very nice to hear. Thank you.
Cool. Well, I think sort of in the interest of time and not to keep you from your Thursday evening a little bit further, this has been a super nice sort of conciliatory note to wrap up what's been an incredibly nuanced discussion on some incredibly hard and difficult and complex questions. So yeah, I mean, I'm very, very grateful for all of your insights. I think the lesson of today is that collaboration between researchers, NGOs, and national authorities is absolutely vital in this. And I think then we might actually be able to make data access useful and make it work. And to sort of end on paraphrasing what Anna said, good citizens of Facebook don't get data access. So let's all try and then mobilize this to the best of our extent. And I'm very, very grateful for your insights. If I may very, very kindly point you to the link that the link to the Irish DSC shared on the survey that's somewhere in the chat that Catalina posted on data access. We can, in the spirit of collaboration, we can help them as well. And yeah, other than that, thanks a lot for your insights and very grateful for your attention.